This is CNN Breaking News.
Welcome to The Lead. I'm Dana Bash in for Jake Tapper. We continue with the breaking news. A federal court in Florida unsealed the warrant that investigators used to search the home of former President Trump. The warrant cites three laws: obstruction, removing of government records, and the Espionage Act. The warrant listed the classification of documents that were seized from Mar-a-Lago on Monday, including 4 sets of top secret documents, 3 sets of secret documents, 3 sets of confidential documents, and various documents were marked as top secret, sensitive, compartmentalized information. This would be material so sensitive that the U.S. goes to excruciating efforts to protect it. Only people with top secret clearance can read these documents, and they have to do it in what's known as a SCIF, or Sensitive Compartmented Information Facility. Now, these SCIFs require a special lock and have reinforced walls and electronic methods to prevent spying. I'm going to go right to CNN's Caitlin Polans. So, Caitlin, you have the warrant. What else are we learning from it?
Right. Well, Dana, there is more information in here than we could have expected yesterday. There is 3 pages that really lay out exactly what was seized from the property of the former president, Mar-a-Lago, that beach club that is also his home and is not a secured facility in the way that the federal government sets up secured facilities at this time. And this list, it walks through, there are 33 items here that were seized as far as this list goes. Most of them are boxes with labels on them. One is a leather-bound box of documents. Within it, it appears, the way this is written, that there are various classified TS-SCI documents that were taken out of Mar-a-Lago, or at least they were labeled as such. TS-SCI is that very high level of classification in the U.S. government, top secret, sensitive, compartmented information. It really is the sort of information that is extremely protected and only certain people are able to access it. This is what is under investigation, not necessarily the classified information, but just the idea that things that could hurt the national defense, that could hurt the United States, were being kept in an unsecure location. And when we look also at what was being searched, how the federal authorities would have been doing their job, we can see that they were given pretty broad direction as to where they were to go to look. They were to look in the office of the former president, in areas and other rooms being used by the former president where there could be documents kept that would be unsecured, things they needed to really get out of that place. And then the other thing that is of interest here is that when this receipt was signed, when it was handed over as the FBI would have been leaving, we see a timestamp of 6:19 p.m. That really does confirm that the FBI worked for most of the day to try and take these things off of the premises and get them back into secure hands.
So interesting. Caitlin, thank you so much for that. I want to bring in our CNN senior justice correspondent, Evan Perez. So, Evan, you said something interesting that I even called you about, because I said, what? This is really critical, and it's about the 3 laws that are cited in this search warrant. You hear the former president or see him in his statements today saying, I didn't take any classified information. But what you're reporting is, reading these laws, is that's not necessarily relevant. Can you explain that?
Well, yeah. So the three laws. I'll read you the three federal codes. One is 793. That's known as the Espionage Act, gathering, transmitting, or losing defense information. Code 1519, this is destruction, alteration, falsification of records in federal investigations. This is an obstruction statute. And then there's the 2071, which is concealment and mutilation of federal documents. What's interesting about, especially, if you look at the 793, which is the Espionage Act, the national defense information, it doesn't really turn on whether, the items are declassified. It doesn't turn on whether you have authority to possess these documents. So the federal government, according to this document, the prosecutors of the Justice Department are investigating possible crimes. This is the proof they gave to a federal judge to say, we believe at Mar-a-Lago there were crimes, evidence of these crimes. What's important about this is that they're using specific laws that could inoculate their investigation from what we expect to be the surefire Donald Trump defense, which is, I declassified everything. By saying so, I automatically declassified things. Of course, we know it's a little more complicated than that, but that's where we know Donald Trump is going to go. We can already see that in some of his defenses. One other thing that stood out to me from this document, real quick, Dana, is the document says that the judge is authorizing the FBI to show up anytime from 6 a.m. to 10 p.m. We know that the FBI showed up around 10 a.m. It gives you a sense of the deference they were giving to the former president for the office that he held. They could have gone in there with their FBI jackets. They came in with suits and ties. They came around 10 a.m. They were trying to not make this a spectacle. He is the one that went out around right after the FBI left the premises and blasted out his statement and has sort of created a spectacle of what had happened here.
Evan, that's very interesting and an important point, because now we do have these timestamps. But back to your original point, if the former president didn't necessarily break the law, just to use layman's terms, because of, or this wasn't precipitated because of his possession of any classified information, what would be the potential area where he did break the law?
Well, what this means is that it doesn't matter that it was classified or not. What they're trying to say, by presenting these statutes as the reason for doing this search, what the prosecutors are doing is saying that this was a violation of the law simply because by putting these documents, which could harm the United States, these are national defense information documents, that you are violating the law. So you could violate the law even if you, as former president, declassified them, which is, I think, is what he's going to argue.
Yeah.
So what this means is that you can break the law even if Donald Trump has already said, I hereby wave a wand and I've declassified things.
Evan, such important context and reporting. Thanks, as always. I want to bring in Tom Dupree, who was the #2 in the DOJ Civil Division under George W. Bush, and also with me, Kim Whaley, who served as an assistant U.S. attorney. So, Tom, you've read the warrant, you heard Evan's reporting and Caitlin's as well. These 3 laws: obstruction, removing of government records, the Espionage Act. What do you make of it?
Well, the big ticket one here, Dana, is the Espionage Act. I think that explains what's been going on behind the scenes at the Justice Department, that what this warrant we see today confirms is that this is just not a garden variety dispute about archiving. It's not a ticky-tack dispute about where presidential records are stored. Rather, this really goes to the heart of United States national security. It's an Espionage Act potential charge. And I think what happened at DOJ was they simply said that these documents that the president is refusing to turn back over to the government are not mementos, souvenirs of his time in office. Rather, they are documents that have a direct material relevance to the national security of the United States. That's why we need them back. And that's why it was appropriate to execute a warrant on Mar-a-Lago.
Kim, what are your thoughts?
Well, Dan, of course, I've just been able to read the warrant and look at these statutes, but there are a couple things that jump out to me. One is the Espionage Act is actually really long. There's a part of it that says authorized users cannot share this information. Whether he's authorized or not, I think is unclear. It's unless he somehow waved his magic wand and declassified things under the Presidential Records Act, he did not have any legal right to have this. So I think it's possible another provision of that act would apply. The warrant, it doesn't say which subsection. The other provisions apply if there's intent to share information in order to injure the United States or to advantage foreign nations. I think that's quite interesting, right? The obstruction statute, also very interesting, because it's not just obstruction by having these things. It's you are destroying or concealing documents in order to obstruct another investigation. So my question would be, what are they, was there probable cause to believe, is the other investigation that these documents in Mar-a-Lago were allegedly, potentially there to obstruct? And then, of course, the last one is more, you just can't you can't destroy or conceal these kinds of documents. So this is, this is potentially decades in prison. Last point I wanted to make is it's unclear whose intent we're talking about here. Of course, Donald Trump is the resident of Mar-a-Lago the owner, but it's unclear from the warrant if they're talking about Donald Trump personally, or if it's him and other people, or it's other people that would have been potentially in violation of these federal laws.